we are all dealing with the impacts of climate change and diminishing water supplies across the West in particular, there's a significant percentage of Navajo tribal members who do not have access to clean drinking water in their homes.
You literally had to figure out the exact location of a steamboat landing before Thompson Falls.
It really was just a deep dive, gathering as much evidence as I could and then analyzing it very deeply to determine, did this actually happen or were these just kind of pipe dreams?
Hello and welcome back to On the Stand with Ashish Arun, the podcast where we go deep on the law, practice and business of expert witness testimony. I'm your host Ashish. I'm the founder of Xlightum, and today we have a truly unique guest. Ian Smith is the History Division Manager and Principal Historian at Historical Research Associates, or HRA, one of the oldest history and archaeology consulting firms in the country. Founded in Missoula, Montana in 1974, Ian has been with HRA for over 25 years, and in that time, he has become one of the leading expert witness historians in the country, specializing in Native American land and water rights, tribal sovereignty, treaty interpretation, and the navigability of waterways. His work isn't rhetorical. He has submitted expert reports and provided testimony, both in deposition and at trial, in cases involving the water rights of the Coeur d'Alene tribe, the Gila River Indian community, the Akchin Indian community, and the Navajo Nation, amongst many others. His research contributed to the Supreme Court's landmark decision in Herrera versus Wyoming, which upheld the Crow tribe's off-reservation hunting rights. His expert report was cited directly by a federal court in ruling in favor of the Confederated Salish and Kootenai tribes in a right-of-way dispute. And his report and testimony helped the Interior Department solicitor determine that the MHA Nation owns the Missouri riverbed and the minerals beneath it. Ian's also a published scholar. He recently co-authored a piece in the American Bar Association's Natural Resources and Environment Journal, analyzing how the Supreme Court uses and sometimes ignores historical evidence in Indian law cases. He's a recipient of the National Council on Public History's Excellence in Consulting Award. He meets the Secretary of the Interior's Professional Quality Standards in History, and he serves as the Vice Chair at Large of the ABA's Indigenous Law Committee. He holds an MA and BA in History from the University of Montana, and his master's thesis examined the impact of federal reclamation and allotment on Quechan Indian lands. So on that note, let's welcome Ian to the show. Ian, welcome to On the Stand.
Thanks so much. Glad to be here.
Yeah, it's a pleasure having you here. So most people don't think of historians when they think expert witness. So how did you end up doing this kind of work? Like, was this the plan when you were studying history at the University of Montana, or did you fall into it?
Yeah, it's actually kind of a funny story. I really did kind of fall into it. When I was working on my bachelor's degree, I actually got a double major in history and English literature. And as I was getting toward the end of my studies in history, I actually had the person who started HRA was one of my professors for kind of the last class that I had. And he ended up actually hiring me on a contract basis pretty soon after my BA. And then I went back to school while working at HRA to get my master's. So yeah, it was kind of a fortuitous situation that I fell into. I don't know if that would happen these days, but that kind of thing. But I do think it underscores the importance of relationships, right? Building relationships. But yeah, I didn't really know that this kind of work existed when I first started my undergrad degree in history. So it was a good surprise.
And now you've been at HRA for over 25 years. So you started as a research historian, and then you worked your way up to running the history division. So tell me, from when you started or the time that you got your first case, have you seen a demand for expert witness historians change over time?
I don't know that I've necessarily seen it change. It's kind of a niche field, I'll be honest. I think that there are certain types of cases where attorneys do recognize the need for historical experts. Native American law, I think, is one of those areas where attorneys do understand and recognize the value of historians, but there are other types of litigation where I feel like the historians with whom I work, for example, attorneys in those cases often think first probably about environmental scientists, right, as experts, but historians can help attorneys understand the broader contextual and narrative arc of what happens, and also work closely with those more science-based experts to understand, pathways of contamination and whatnot. Like, there's still kind of a learning curve, I feel like, in terms of getting attorneys to understand how historians can be valuable in cases like these.
And I mean, I know you wouldn't have an elevator pitch for why should attorneys working on environmental cases should work with historians. But for somebody who's never worked with one as an expert,
Yeah.
what would you tell? Like, what are some of the unique perspectives that you have brought to cases as a historian that
Right.
you would want attorneys to understand that, okay, this is how a historian would be really good to the experts team in the case?
Yeah, I mean, I think in a couple different ways. One, we're really good at finding information that's difficult to find, right? So we are really adept at ferreting out and finding information in dusty archives, where the records haven't been digitized, right? Which is one assumption I think that some people make, that everything's been digitized now, which is not true. And we're able to kind of dig in and find collections of records that can help a case. And then a second way that we are, as testifying experts in particular, but also as consulting experts, we can be helpful in really contextualizing the evidence that we do find, right? And really good expert historians, when they're on the stand, I think are able to concisely and clearly tell a story to the judge, right? That's about topics that are often arcane and a bit esoteric. And we're able to communicate that clearly and concisely to a judge. Oftentimes we're not working in cases where there's juries involved, but I think that's very helpful, both in the kind of trial testimony setting, but also in the background when we're just consulting with attorneys and helping them craft their briefs, right? Which can be useful as well. I mean, bringing historical evidence into the brief into a legal brief can be very useful for attorneys and can be impactful for the case as well.
So, do you mind walking us through your process? Like when an attorney calls and says, hey, we need historical evidence to support our clients, let's say water right claims.
Yeah.
Like what happens next? Where do you even start?
Right. So I should say, typically I work in the context of tribal water rights, as we've been talking about a bit here. It's a little different if you're working on non-native water rights claims because the legal principles are different, right? But in the context of a tribal water rights case, I would start with trying to understand how the reservation was created, right? Getting a good sense of whether that reservation was created by treaty, by executive order, by legislation, and when those things occurred. And that's because of the legal framework within which tribal water rights get adjudicated, which is typically within the context of what's called the Winters Doctrine or the Federal Reserve Water Rights Doctrine. So it's really important kind of as a first step to get that really basic understanding of when the tribe's reservation was created and how it was created. And then we really need to start digging deeply into ethnographic and other published literature to gain an understanding of how tribal members had used those lands and waterways prior to the creation of the reservation, because that and dictate not only the purposes for which the reservation was created, but also the ways in which tribal members have used waters from time immemorial. Because in the tribal water rights context, there are kind of two different pathways for tribal water claims. One is through the reservation of lands by the federal government through treaties or executive orders. And the other is through this time immemorial use of waters that tribes will have reserved to themselves long before their reservation was ever created. So that's kind of a long-winded way of getting to that. But yeah, when I get a call, it's often, it's understanding that history of reservation creation and trying to get at pre-reservation uses of water, and then thinking about how am I going to do the research to provide that foundational understanding. And it takes time. It takes a while, as you might imagine.
Today's episode of On the Stand is brought to you by Xlightum, the AI-powered platform where attorneys find expert witnesses and experts grow their practice. Every week, hundreds of new experts join Xlightum, giving attorneys instant access to qualified witnesses without any finder's fee or markups. Need someone else to handle the vetting? Our concierge service does it all. You only pay when you retain an expert we present. So whether you are searching yourself or letting us do the heavy lifting, Xlightum makes expert discovery fast and smarter. Visit Xlightum, that's exlitem.com, to find your next expert witness today. So I'm going to trivialize this a little and ask you, why wouldn't an attorney or a paralegal be able to do this research and get the context on the creation of the water rights and the other issues that you would opine on as a historian?
Yeah, so I think sometimes there are attorneys and paralegals who do some of this kind of research. Oftentimes, Native American law attorneys have kind of a historical background and are pretty used to looking into history. But again, I think that as historians, we are able to uncover additional materials that a paralegal or an attorney wouldn't be able to find necessarily, right? And then the other piece that I think is maybe even more important is that contextualizing piece that I've talked about before, where as historians, we're able to really think through the ways in which the various pieces of evidence connect to one another that often aren't apparent to someone like a paralegal or even an attorney who's maybe not thinking historically in the way that a historian does. And oftentimes in these Native American law cases, we're having to opine on things like how would a tribal leader or tribal negotiator have understood a specific term in a treaty that's kind of ambiguous, right? You need a historian in that situation to be able to opine on would a tribal leader have understood the word unoccupied, for example, to have meant in 1868, right? Oftentimes those, even the treaty negotiations the minutes of the treaty negotiations won't specifically talk about that particular issue. So you really do have to bring in these contextual pieces of evidence and think historically to be able to provide a clear, concise, and convincing opinion about what tribal leaders would have understood a term like that to mean. Yeah.
That's really helpful. And I would imagine that you would also end up testifying a lot in cases that do go to trial, because again, like the perspective that a historian would bring, and just the experience of looking at history or creating a narrative that appeals to the jury would make historians great on the stand. So I have two follow-up questions. Like one, what percentage of the cases where you work on end up requiring you to testify? And secondly, you actually presented on the distinction between consulting and testifying expert roles at the American Historical Association's annual meeting. So can you also, for the benefit of our audience, tell us why it matters strategically, the
Yeah.
difference between a consulting and a testifying expert role?
hmm Yeah, so those are interesting questions. So I would say that the percentage of cases in which I end up testifying at trial differs a bit between certain case types. For example, I do a lot of work in a water rights context. And in those cases, I often end up testifying in deposition settings, but not at trial. And the reason for that is that there is a strong incentive for everyone involved in these water rights cases to actually settle the case, rather than having them go litigate them all the way to trial. And the reason for that is one, the cost of litigation, but two, and probably even more importantly, is that a water rights settlement gives what tribes often refer to as wet water, meaning that through a settlement process, they're able to get promises for water development. You know, in a lot of these water rights contexts, like Navajo Nation, for example, there's a significant percentage of Navajo tribal members who do not have access to clean drinking water in their homes. So it's really important for a lot of these tribes to ensure that through water rights settlements, they're able to not just get what they often refer to as a paper water right, which you get through litigation, but rather wet water that they're able to get in their homes, you know, piped into their homes. And that typically happens through water rights settlements rather than litigation. So that's one reason why, in a water rights context, a lot of these cases don't go to trial. Some of them do, but a lot of them don't. In other contexts, like thinking like about treaty rights, like I think we'll be talking a bit about the Herrera case, for example, where you're dealing with off-reservation hunting or fishing rights, or navigability cases, right? There's still an incentive to settle those if possible, right? For a variety of reasons, but those are probably more likely to go to trial, I would say, than a water rights case. Just because settlement, I think, sometimes is more challenging to achieve in those contexts. And oftentimes I think the parties are in those contexts maybe need or want to establish the jurisprudence, which you only get through the litigation process, right? You get an actual court ruling, you know, that says, you know, this is what X means and this is what Y means in that context. I will say though that the current complexion of the Supreme Court makes it a little challenging, I think, for Native American law attorneys to maybe want to go all the way to the Supreme Court, for example, because it's kind of an unknown right now as to how the court will come down on those cases. But yeah.
No, I'm sorry to cut you off, but so while we're talking about the Supreme Court aspect, let's talk a little about the Herrera versus Wyoming case, which went all the way to the Supreme Court, about the off-reservation hunting rights. And your firm's research actually supported the legal briefs in that case. So can you tell us what was the historical question at the heart of that case? What did the archival record reveal? And what was your role in the case?
Yeah, absolutely. So this one was a little bit different than our typical cases because I didn't get involved in it. Our firm didn't get involved in it until it was at the Supreme Court. And so Supreme Court doesn't actually take expert testimony. So the only way that you can get historical evidence into the record is through kind of the briefing process. So I was working with attorneys for the Native American Rights Fund who were representing the Crow tribe in the case. And the case really turned on, I think I've referenced this before, but it turned on a provision in the Crow tribe's 1868 treaty under which they reserved to themselves the right to hunt on, I think the term was something like unoccupied lands of the United States, so long as game remains thereon and peace subsists in the hunting districts or something like that. That was the phrase that was really the crux of the case. And what had prompted the case was that a Crow tribal member had hunted in an off-reservation area on lands that had been reserved by the United States as part of the Bighorn National Forest. So the question really came down to, it was kind of two pieces. One was, did the reservation of those lands and the United States placing them into a national forest reserve put them into a quote unquote occupied status under the terms of the treaty? And then secondly, the state of Wyoming was arguing, and their argument was largely based on like a hundred or so year old case that the Supreme Court had ruled on, I think in 1896, suggesting that when Wyoming became a state, which I think was in 1890 after the treaty, did Wyoming's statehood implicitly abrogate the off-reservation treaty right? So the historical aspects that I think were helpful in this case were really looking at the treaty minutes, but also at broader anthropological literature surrounding the tribe to get an understanding of what tribal leaders would have understood the term unoccupied to have meant at the time the treaty was negotiated in 1868. And just to step back quickly there, the reason why that's important is that the Supreme Court, like in a series of cases in the 1830s, established what is often referred to as the Indian canons of construction. And so under those canons of construction, the Supreme Court has said that treaties with Indian tribes need to be interpreted as tribes would have understood them, and not, I think there's language in one of the early rulings about like, you shouldn't interpret the language of treaties as learned lawyers would have understood the terms, but rather just as how did the tribes understand these terms? And then if there's ambiguity in the language or the terms of a treaty, those ambiguities need to be resolved in tribes' favor, not the other way around. And then the third prong of the canons of construction is really that the Supreme Court has said that you need clear, explicit evidence that Congress subsequently intended to abrogate a treaty provision in order for a treaty right to have been abrogated or expunged. So that's where the historical evidence or how the legal framework within which the historical evidence was used in the Herrera case was really framed in that canons of construction framework. And so we were able to convince the court ruled in the tribe's favor that the tribes would have understood the term unoccupied to have meant not settled, right? Not settled by non-natives. And so the establishment of a national forest, obviously people can't settle inside of a national. So there was that. And the court also ruled that the old 1896 racehorse decision on which Wyoming was relying to say that statehood had impliedly abrogated the Authorization Treaty, right? That was no longer a good ruling, based on a subsequent case in Cult Mille Lacs.
No, but it's really interesting. And again, like talking to you and listening to you explain the whole background, again, I can see why historians would really be important to be brought in as experts on these cases. But on the flip side, Ian, you also co-authored a recent ABA article analyzing Arizona v. Navajo Nation, where Justice Kavanaugh's majority opinion essentially ignored the historical record. And please correct me if I'm not getting it right. But he essentially ignored the record which showed how central water was to the Navajo Treaty negotiations. So what's your take on that disconnect?
Yeah, I do agree that he basically ignored it. I'm obviously not an attorney, nor am I a judge, but I think that his ruling was very narrowly written, right? To his interpretation or his reading was based very narrowly on the Supreme Court's breach of trust jurisprudence. And because he did not find that the Navajos' 1868 treaty, interestingly the same year as the Crow Treaty, did not require the United States to take what he referred to as affirmative steps to secure water for the tribe, that there was no breach of trust under that breach of trust jurisprudence that he was, I think, too narrowly deciding a case on. And I think you see that when you read Justice Gorsuch's dissent in that case, you really see the tension between the Kavanaugh approach and Gorsuch's approach. Gorsuch, interestingly, is a Westerner. He seems to be very knowledgeable about tribal history, tribal sovereignty, and he really focuses on the importance of these Indian canons of construction that we talked about earlier. So it's interesting to read his dissent in connection or alongside Kavanaugh majority opinion to kind of see where, to me, I think that shows where the tension on the current Supreme Court lies with respect to Native American treaty rights at this time.
Let's talk a little about, like the case where you testified on behalf of the United States, the Red Lake Reservation boundary case. And it was like the District Court and the Eighth Circuit, they both relied on your report. So tell us about that experience. What was it like testifying at trial on behalf of the United States?
Yeah, that was actually the first case that I ever testified at trial on. I had previously testified in a case, but that was just deposition testimony. So it was interesting from that respect to see the differences between deposition testimony and trial testimony, which I'm sure your listeners have heard this kind of thing before. But in my view, when you go into a deposition, I think about it as you can only kind of lose points. Like you start with 100 points and you can only lose. And your goal in a deposition is really to kind of hold your ground and not give the other side ammunition for future attacks on you and your client's case. In a trial setting, by contrast, you actually have the opportunity to kind of put forward your affirmative opinions, which obviously you do in your expert report, but it's helpful to be able to do that, I think, verbally, and to be able to again, kind of concisely provide your opinions in front of a judge. Obviously, you do have to deal with cross-examination in a trial setting, and you need to be prepared for that. Cross-examination can sometimes feel a bit like a deposition, but it's helpful, I think, having the judge there too. In a deposition, like, there's no, obviously your attorneys can object to something that the other side's asking you, but you pretty much have to answer the question anyway. But that was a kind of an eye-opening experience, just from the perspective of, like, it was my first time testifying in a trial setting, and really understanding the differences between deposition and trial testimony. What was also interesting about that case is that it was actually a criminal case. So typically, the work that I and my colleagues do occurs within the context of civil cases, right? Water rights adjudications, treaty rights cases, that kind of thing. They're all within civil litigation, but this was actually a criminal case. And what had prompted the case to begin with was that the alleged perpetrator of an attempted murder, the alleged murder had occurred on a parcel of land within the exterior boundaries of the Red Lake Reservation. And he was claiming that because that particular parcel of land had been sold to a railroad company in 1905, that it had become diminished and not part of the reservation anymore through that process. And the real underlying reason for that, I think, is that he was trying to avoid federal sentencing guidelines. But so my role in that case was to look at the legislative history of that law under which that particular parcel of land was sold to the railroad company, to determine whether there was any evidence that Congress intended to diminish that parcel, make it not part of the reservation anymore. And what I found, and what I opined on in testimony at trial, was that there was no evidence that Congress intended to do that. And thus, even though the parcel was owned by a private entity at the time the crime was committed, it was still, quote unquote, Indian country within the meaning of the law, because Congress had not intended to diminish it from the reservation. It was also interesting at trial that the alleged perpetrator of the crime was actually in the courtroom so, while I was testifying. So that was also a little different for me and interesting as well.
So, from what I understand, like, water rights are arguably the most consequential area of Indian law litigation happening right now. So, can you give us a sense of the scope? Like, how big are these cases, and what really is at stake?
Yeah, I would say tribal water rights are a big issue right now, in Indian law, and writ large too, as we are all dealing with the impacts of climate change and diminishing water supplies across the West in particular. I think water rights cases are always been important, I think, but they're increasingly important in the context in which we find ourselves of diminishing water supplies. One of the things I think that's important for listeners to know is that the vast majority of tribal water rights cases, modern ones, happen. This is because of what was called the McCarran Amendment, Congress passed in 1952. Most of these cases actually occur within state courts, not federal courts. So most tribal water rights litigation and ultimately settlements come out of a statewide water rights adjudication process. And so there are a few really old cases that don't fit that model, but by and large, tribes and the U.S. on behalf of tribes are making water rights claims and adjudicating these tribal rights within the context of state courts. And I think that's important to know, in part because like there are differing levels of understanding among different states and different state court judges about the legal underpinning of tribal water rights and kind of a federal reserved right process. So in certain states that have been engaged in water rights adjudications for decades, like Montana is one of them, Arizona is one of them, those you tend to see courts and judges who have a better understanding or maybe a more in-depth understanding, recognition of tribal federally reserved water rights. In other states that are maybe just starting their statewide adjudication process, there's kind of a learning curve, I think. So that's just an important foundational thing to understand about tribal water rights in general. But yeah, going back to what we were talking about earlier regarding the Winters right or the Winters doctrine and federally reserved water rights in general. Again, like the basis upon which tribes are able to make water rights claims, whether it's in state court or federal court, really derives from the Winters doctrine and another case called Winans, which was decided around the same time as I think Winans was decided by the Supreme Court in 1905 and Winters was 1908. And the real kind of, in a nutshell, what those cases say is that courts need to understand the purposes for which the tribal reservations were created in order to determine both the types of water rights that tribes can claim and ultimately the quantity of the water that they can claim. So again, the types of water rights that a tribe can claim really differ based on where the tribe is located and what types of water uses tribal members had used water for since time immemorial. So if you're talking, for example, about a tribe in the Pacific Northwest, right, that relied on salmon fishing extensively for its traditional subsistence practices, you will see tribes like that able to make in-stream flow claims, or basically to keep water in the river in order to facilitate their ongoing rights to fish in waterways, right? Whereas a lot of tribes in the Southwest, for example, Gila River, Ak-Chin, Agua Caliente, those types of water rights are more based in agricultural uses and what's often referred to as the PIA standard, practicably irrigable acreage standard. So tribes in those contexts are often trying to say when the reservation was created, one of the primary reasons or purposes for the reservation was agriculture, and we have X amount of irrigable or practicably irrigable acres on the reservation, so we're going to make a claim for Y amount of water to support those original purposes of the reservation. And that's true even if, say, for example, the tribe has 50,000 acres of practicably irrigable farmland on their reservation, but they've only put water to 5,000 of those acres up to the present time. They can still make a claim for the full 50,000 acres because of this reserved water rights jurisprudence. So, or that legal framework, the Winters Doctrine. Yeah, and that's different than like a non-native claimant who has to prove beneficial use of the water, like putting the water to beneficial use in order to make a claim for a certain amount and to establish that priority date. Oh, and one other thing, speaking of priority date, I should go back. So throughout the West, most of these states operate under what's called the prior appropriation doctrine. So the water rights are often tied to a specific date, right? So tribes, depending on the type of use that they're putting the water to, will make claims for water that are tied to the date of the creation of the reservation, for example. Those will be tied. Yeah.
Wow, but that would be like 150, 200 years ago. So how do you even document something like a pre-reservation water use when it's that old?
Yeah, it often is. Yeah, you're talking like here, I'm in Missoula, Montana, and just north of here is the Confederated Salish and Kootenai Tribes Reservation. It was created in 1855 through a treaty, and long before non-native settlement. So when you think about that in the context of the prior appropriation doctrine, those tribal water rights, many of which remain unquantified, will predate most, if not all, non-native water claims. So it's an important thing. But in terms of your question about documenting pre-reservation water uses, so a lot of times I'll use published ethnographic studies. Also things like fur traders journals that will talk about encountering tribes prior in the 1810s or 1820s. Lewis and Clark's journals sometimes will talk about specific tribes that they encountered during their expedition. And then another great source of evidence is in the mid 1900s, like 1950s, 1960s, and into the 70s, many tribes made claims under what was called the Indian Claims Commission Act, where Congress authorized tribes to sue the United States for what was referred to as unconscionable consideration under the treaties, where they gave up lands but got paid very minimal amounts. Under this Indian Claims Commission Act, they were able to sue the United States and get compensated at a more appropriate, I think maybe still not high enough, but a little bit more compensated than they had been originally under these treaties. But part of the body of evidence that was used in those cases was expert testimony from anthropologists and ethnographers. So oftentimes, because the tribes had to make the case that they were actually using various parcels of land or tracts of land that they had ceded under the treaties. And so that evidence, and sometimes there's testimony too from these anthropological experts, is really useful in terms of understanding how tribes were using waters and lands long before reservations were created. So it's kind of a wide variety of of sources that we rely on to
And have you,
get that understood.
yeah, and have you ever come across an instance where the historical record is just silent? Like, has that ever happened, or you'd usually find some reference or some record?
Yeah, well, so a lot of times in these cases, like when we were talking about Herrera, for example, the Herrera case, there's often not super direct evidence of the specific question you were looking for, right? Like, what did the parties intend for the term unoccupied to mean, right? You're not going to really find specific evidence of that either in the treaty negotiation minutes or in subsequent letters written about the negotiations. So I think in a lot of instances in these cases, it really is pulling together a lot of contextual evidence to try to gain an understanding of, again, what tribal leaders and tribal negotiators would have understood these terms to mean, right? And again, so that goes back to the importance, not to pitch too much for like why historians are helpful, but I think it really does underscore how we can help in cases of these types to contextualize evidence and then present a clear and concise opinion that's based on contextual evidence that we bring forward through the historical method and thinking historically. Yeah.
And in another, like, I know I'm going through one case after another that you've worked on, but they're all really interesting, very unique. So one case I really wanted to talk about was the Clark Fork River case,
Yeah.
where you testified about whether steamboats traveled a particular stretch of river before statehood. You literally had to figure out the exact location of a steamboat landing before Thompson Falls. How do
Yeah.
you do?
It was fun.
I can imagine, but still, how would you figure that out?
So again, it was really like digging into little tidbits of information, a lot of historical newspaper research,
Mhm.
pulling that kind of stuff, as well as archival records. There were some records of archaeologists who had tried to dig up to find the location of this site, or kind of amateur archaeologists. And I used all of that to try to determine the location of that landing, where it ended. Because there was, I guess, to step back, the case, this particular case, turned on who owned the bed and banks of particular stretches of the lower Clark Fork River. And why that mattered is that the state of Montana, there were dams that had been placed by private companies on areas where previously there were waterfalls, right? And the state of Montana was saying that the state owned the bed and banks of the entirety of that stretch of the river. And because of that, the state wanted to basically charge lease fees to the private entity that owned the dams on that stretch. Under navigability law, there's a presumption that the state will get title to the bed and banks of waterways that were being used for commercial purposes prior to statehood. And so one of the ways that you can prove that there was commercial use of a waterway is through things like steamboat traffic, right? And so that's why this whole question mattered in this case. And so there was clear evidence that steamboats did ply the waters of the lower Clark Fork, but the question really turned on, did they go through these waterfalls, and then did they go upstream of of Thompson Falls, right? And to determine like where exactly this commercial activity occurred. And in those areas where commercial activity had occurred, if the state would actually own those portions of the bed and banks of the waterway. And in those areas where there wasn't commercial activity, the state would not own it, and the private entity would. And that's all based on a Supreme Court jurisprudence that calls for these kind of segment by segment analyses of waterways when you're trying to determine who owns the bed and banks. So anyway, what I found was that there was evidence of steamboats going upstream, but what they would do is in the late 1860s, which was 20 years before Montana statehood. But what these steamboats would do, they would go up to the waterfalls, the existing waterfalls where the dams are located now, and then all the passengers would get off and then hike around the falls, and then get on a second steamboat and then go up to the next waterfall and then hike around that. And the question was whether there was another steamboat and there was evidence in the historical newspapers that I looked at that there was clearly an intent or desire to build another steamboat that would go farther upstream past Thompson Falls. But when I really looked deeply at what those articles were saying, there was no evidence that it was anything beyond an intent or an aspirational vision of establishing steamboat traffic upstream of Thompson Falls. So yeah, it really was just a deep dive, gathering as much evidence as I could, and then analyzing it very deeply to determine, did this actually happen, or were these just kind of pipe dreams, so to speak, of steamboat traffic upstream Thompson Falls. And the court found in our favor. So
Very it's really fascinating. We got to work on. But you recently wrote an article where you talked about Justice Thomas's concurring opinion in Arizona versus Navajo Nation, where he essentially challenged the very foundation of the Indian canons of construction and the federal trust relationship.
yeah.
Now, no other justices joined him, but you flagged it as something to watch. So
Yeah.
why should attorneys be concerned? And if the Indian canons erode, what happens to the role of historical evidence in these cases?
It's a good question. I do think Native American law attorneys should watch this, in part because of what I was talking about previously regarding the tension between Kavanaugh and Gorsuch. And no other justices joined Thomas's concurring opinion, but he really did attack the canons of construction and really the federal trust relationship with tribes, claiming that it didn't have a basis in the Constitution. I just think, obviously, no other justices joined him in that opinion. But if that kind of reasoning begins to hold sway with anyone beyond Justice Thomas, which I'll say hopefully does not happen, it would be a significant change in how Indian law cases are decided going forward, because they are so rooted in these canons of construction and in the federal trust relationship. So if that were to happen, which hopefully will not happen, it will be an important thing to watch. And I don't know, I mean, in terms of how the role of historical evidence will change, it's hard to say. I mean, it would depend, I think, on if this were to happen, how it happens, how the ruling, what the specifics of the ruling are under which it happens. Again, I'm just hopeful at this point that that nothing happens to the Indian canons of construction, and the Supreme Court doesn't attack the federal trust relationship with tribes. But I think it is something to watch just because of the nature of the court right now.
So, what would you say attorneys should look out for when they are working with an expert witness historian? And are there any mistakes you see attorneys make? Are they like bringing in historians too late, or are you usually brought in early in the case?
Well,
Any thoughts?
I do think it's important to the extent possible to bring historians in as early as you can, right?
Mhm.
I don't know that there's necessarily a too late, but but the earlier the better, right? Because a lot of times the historical research and analysis that we do as historical experts can help shape attorneys, the case the attorney brings. In some instances, attorneys can go into litigation or be preparing for litigation with a certain legal approach in mind, and the historical evidence might not fully support that, right? Or may require them to shift it. And it's better to do that early in a case than it is very late in a case, right? It is important for historians, if you are finding evidence that doesn't support the legal theory that the attorneys are putting forward, it's really important for us as expert historians to talk with the attorneys about that, whether that means that they need to shift their legal theory or that they just need to be aware of, some countervailing evidence that's out there so that they can be prepared for it. The thing I always tell my colleagues and my clients too is like, you want to know both the good, what the good evidence is that supports your legal theory in the historical record, but you also want to know about the potential challenging evidence or not so good evidence that's out there too, so that you're prepared for it well in advance of deposition or trial. So yeah, that all kind of speaks to the importance of getting historians on board as early in the case as you can. And also just because research takes time. Again, it's not everything is digitized, and we do still have to go to archives and work with these old dusty boxes, So,
What's the favorite part of the job? Is it the archive or the courtroom?
Not to be a fence sitter, but I really like both aspects of it. It's really fun, like working in an archive. It's kind of amazing to me, even 25, 26 years after starting doing this, that I can have a job where I can get paid to like go do research at an archive. That's kind of cool. But then I also really like on the back end, like getting back to the office and analyzing the records that we collected and being able to put that into a well-written, well-crafted expert report. That's another great part of the job. And then a third, the being testifying, that aspect, it can be uncomfortable at times, especially in deposition settings. But as long as you have done a good job preparing and you feel solid in your opinions, it's actually can be kind of fun being on the stand.
And what's the best piece of advice you've ever gotten about testifying, either in deposition or testifying in court?
Yeah, in deposition, I would say the best piece of advice is that sometimes less is more. And if you can answer with a yes or no, that sometimes is the best answer in deposition.
I think that's like much on the point. So thank you so much, Ian, for taking out the time to and talking to us today. This was really interesting and it was very fascinating for me. And I'm pretty sure this will make for a very interesting episode for anybody who comes across it. So if people want to reach out to you for a follow-up or just if somebody is looking for a historian expert witness, what's the best place to find you?
Oh yeah, you can so you can email me at ismith@hrassoc.com. HRA also has a website. It's www.hrassoc.com. And you can find me on LinkedIn as well, Ian Smith on LinkedIn.
Perfect. We will add all of that in the show notes, and they'll be all in the captions when the episode comes out. So once again, thank you so much, Ian. It was lovely having you over, and we'll look forward to the new cases and the new issues that come your way.
Yeah, thanks so much. It's been fun chatting with you.
If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.